Embattled Boku Central MP Mahama Ayariga declares before High Court he will prioritize its tax fraud proceedings over his parliamentary duties, despite latest ruling by Speaker of Parliament asserting his immunity. Tonight, the High Court has, for the second time today, thrown out Parliament's latest ruling, insisting the MP is not entitled to immunity.
This is Topstory with Evans Mensah.
Topstory is always brought to you by Bond Savings and Loans. Your success, our passion. Also brought to you by Gassam Cement, the nation builder. Vodafone. The future is exciting. Ready, a nationwide medical health insurance, your healthcare family. For the second time in a week, the High Court has thrown out another ruling by the Speaker of Parliament, asserting the partial immunity of embattled Boku Central MP Mahama Ayariga. In fact, in a surprise move today, Mr. Ayariga himself declared before the court that he will prioritize its proceedings into tax fraud charges against him over his actual duties as MP. Now, his decision to address the court today and yield to its dictates comes despite the second ruling by the Speaker of Parliament, who had backed Mr. Ayariga's earlier claim to immunity under the Constitution. The court, presided over by Justice Ifeanyi Sewa Botre, for the second time held that he is not entitled to immunity, as it's ruled that Mr. Amidu, that is a special prosecutor, can press charges against the MP. The Speaker of Parliament, Professor Michael Quay, on June 6th wrote a second letter to the High Court asking the court to honor time-tested privileges and immunity so as not to affect the work of the MP. This was after the first decision by the court to throw out the Speaker's first ruling on this matter. Now, the court disagreed on this second matter as well, saying all accused persons must show up when they are called upon, and only the court can make that determination. Well, my colleague Joseph Akablay witnessed a drama in court and joins me in the studio. Let's start, Joseph, first on the circumstances that led to Ayariga addressing the court.
So it was at a point that the court was fixing the date for the next hearing, and some of the lawyers had wanted to make the point that it appears they wanted the times to be fixed that would be favorable to them. It was at that moment that we saw Mr. Ayariga on his feet asking to speak, and he informed the judge that he will indeed show up anytime he's needed. And in fact, he says he was actually on a trip, but he had to cut short the trip and show up in court due to the court date. And
here where it gets interesting, because the time he was doing this, the court already had before it a second ruling of the Speaker of Parliament that actually backs Mahama Ayariga's original position.
Yes.
But this particular address seemed to shift from that original position and then depart from the Speaker's ruling.
Yes, in fact, if you recall, the very first time the case was called, that certificate when Mr. Ayariga showed up subsequently after failing to show up in the morning, when he was given a 1 p.m. deadline to show up, he turned up in court and submitted the certificate, which the court ruled that immunity does not apply because Mr. Ayariga is an accused person and not a witness of the court or someone who the court is trying to serve. We can make reference to that letter that was written, the second one from the Speaker of Parliament to the Registrar of the Court, and portions of it reads that...
And this was addressed to the Registrar, the High Court, Financial Court 2, Accra, and written by the Speaker himself, yes, addressed to the court. Let's go through the details of it. And this was before the court today.
Yes.
Okay. What does it say?
So portions of it reads that in consideration of the submissions of the Honourable Member in the Leadership of Parliament, I proceeded to make a ruling on the matter pursuant to articles above mentioned of the 1992 Constitution and Orders 5 and 98 of the Standing Orders of Parliament. The ruling included releasing the Honourable Member while the House was sitting to appear before this court at the appointed time. I have attached the copy of the ruling on the 4th of June 2019 on the matter. In my ruling, I underscored the need for the recognition of the usefulness and relevance of the constitutional privileges and immunities that are accorded the Speaker, members of Parliament and clerk to Parliament, and indeed other members in other arms of government. The combined effects of the provisions on privileges and immunities is to ensure the smooth administration of the judicial, legislative and executive governance of our republic. I provided in my ruling that I trust that the court will honor these time-tested privileges and immunities and to judicially manage the case so as to ensure the ends of justice are met, and yet equally that the work of Parliament as an institution and the representative function of the Member of Parliament for the people of Boku Central will not be impeded.
Okay, now hold on there, because he talks about underscoring the need for recognition of the usefulness and relevance of the constitutional privileges and immunities that are accorded the Speaker, members of Parliament and clerk to Parliament, and indeed other members in other arms of government. And it essentially argues that if the court unnecessarily interferes without recourse to the constitutional provisions, it will impede Mama Yariga's ability to serve his constituents. And then he cites particular clauses in the Constitution for the attention of the judge. Article 117, which says civil and criminal processes coming from any court or place out of Parliament shall not be served on or executed in relation to the Speaker or member of clerk to Parliament while he is on his way or attending at or returning from any proceedings of Parliament. And then Article 1181 as well, that neither the Speaker nor member of nor the clerk shall be compelled while attending Parliament to appear as a witness in any matter. But this time also adds Article 122, which says that an act or omission which obstructs or impedes a member or officer of Parliament in the discharge of his duties or affronts the dignity of Parliament or which tends either directly or indirectly to produce that result is contempt of Parliament. And let's note, his first ruling excluded this particular provision. He didn't add this provision. He's added it now and brings it to the attention of the judge. In fact,
he concludes that letter by saying that kindly bring to the court's attention that the above constitutional provisions, my ruling on the parliamentary privileges and immunities, and they hope that while recognizing that no one is above the law, yet privileges provided under the Constitution are also applied. Please accept the assurance of my highest esteem.
Okay, so what did the judge then say about this ruling of the Speaker of Parliament today?
In fact, I'm reading from the decision that was rendered today. It says, I shall conclude this ruling by making a comment on a letter addressed to the Registrar for the Court, authored by the Right Honourable Speaker of Parliament, on the availability of A1, Mama Yariga, to stand trial. I shall not go into any great detail regarding this letter, safe to say that the concerns therein contained are very well noted. However, in the ruling of this court dated 4th June 2019, in the case of Republic versus Hajia, Ninchema, and 6 others, and the 6 others includes Mr. Ayariga, this court made a pronouncement on whether or not the Speaker's certificate issued on 4th June 2019 will be binding on this court, given the fact that the first accused person is not being compelled to appear as a witness but as an accused person. Those remarks still hold valid, as there is no such need perceived. Safe to state that in considering how this case will be managed and the trial conducted going forward, the following will be the guiding principles. A. An accused person has the right to a speedy trial. While appreciating a very important duty these most respected lawyers are engaged in as legislators, there will be no situation, to borrow the words of Justice Adenyira in the ex parte Francis case, conducting the business of the court as though it is secondary to that of counsel or anyone else for that matter.
In other words, you see, the judge is saying the business of the court is superior to anything else, not even the work of an MP.
Yes, and he continues to say that the court will be sure to deliver on its mandate to preside over this trial like all others before it in a fashion that will terminate it timeously. He concludes by saying that adjournments are largely within the discretion of the court and application should be considered with the primary objective of ensuring a speedy trial, a speedy hearing and determination, presiding judge to have control over his court.
It's interesting. And one more point. The substantive matter before the court today, though, was some application, I think, that has been made, right, by Ayage's lawyers, yes, referencing a case at the Supreme Court, which in essence says that the special prosecutor sort of didn't have...
So they had raised issues about the fact that he signed a charge sheet and they say he's beyond the age of 65 years, he's supposed to be on retirement and is therefore not fit to hold the office and cannot issue any such charge sheets. But the court was of the view that because the case is pending at the Supreme Court and also the court has not injuncted Mr. Amidi from performing the functions as special prosecutor, so is the substantive de facto special prosecutor and can therefore proceed to perform such functions expected of him.
Okay, so Ayaga lost that.
Yes.
Today, and so the attempt to stop the special prosecutor to do his work on the basis of his age, which is a subject of a Supreme Court,
was thrown out
today. Okay, we're just learning that the Ayariga's lawyers are going to be appealing that particular decision. We can speak now to a member of his council, a member of his legal team, who's also a member of Parliament, James Agaga. Mr. Agaga, thank you for your time on Top Story.
Good evening, Evans.
Yes, so I understand that you disagree with the ruling of the court today.
Yes, we disagree with the ruling in respect of one, the um, verdict of the court on the eligibility of the special prosecutor and how the court ought to have, um, if you like, responded in the face of the obvious fact, which is that there is a suit pending before the Supreme Court, which calls into question the very eligibility of the special prosecutor, to have been appointed, nominated to occupy that office in view of the fact that he's well over 65 years, and yet under Article 199, the Office of Special Prosecutor is a public service office. The court came to the conclusion that, yes, indeed, a matter is pending before the Supreme Court and that it didn't have the jurisdiction to interpret the Constitution. So it would leave the issue of the interpretation of Article 199 vis-a-vis the appointment of the Special Prosecutor for the Supreme Court to interpret. Having said that, the court then proceeded to indicate that it was unable to stay proceedings because if it did stay proceedings, that would have the effect of an injunction, and it wouldn't do so because the Office of Special Prosecutor is a statutory office, and that once the Special Prosecutor is performing his statutory function, having been duly sworn in as Special Prosecutor, it would be wrong in law to do that. But Evans, we have issues with that ruling, and as counsel, we are going to test that part of the ruling on appeal. So I will not want to descend into the merits of our appeal because that would be prejudicial. But the point that needs to be made is that we are very aggrieved with the decision of the court not to at least stay proceedings and allow the Supreme Court to deal with the matter that it is seized with. So that is a point that we have taken note of and would want to exercise our right of appeal in relation to the issues we raised concerning the eligibility of the Special Prosecutor and the fact that once the Supreme Court is seized with the matter, the court ought to have at least stayed proceedings or made a referral, all the same. But the court itself took judicial notice of the pendency of that suit. And so one would have expected that the court, in the circumstances, would have stayed proceedings, but the court thought otherwise. So we shall exercise our right to appeal. We have our client's instructions and would act accordingly. But Evans, on the issue of
the court's decision to reject the second ruling of the speaker, is that what you're addressing?
Yes, Evans, I am not sure the court rejected the ruling of the speaker. I haven't read the detailed judgment because what the court did essentially today.
We just got a copy of it, which we shared. The judge said that her original position, which was articulated last week, I think, stands in the face of the second ruling that she got today, the letter that the speaker addressed to the registrar.
Yes, but Evans, you would recall that the letter that was earlier sent, the certificate that the speaker issued and copied the court, was in relation to Article 118.
Except that this latest letter that the speaker sent references that, but also adds 122 as well. Yes.
So I just want to make the point that the speaker actually sought to raise the issue of immunity, which is constitutionally guaranteed, and for the court to take notice of the immunity that members of parliament, including the speaker, enjoy. But the position the court has taken, we have serious issues with that. We think that the issue of parliamentary immunity is something that is guaranteed under the Constitution, just as judicial immunity itself, because judges have immunity,
They do.
Whilst they sit in the normal course of the conduct of business, they have some immunity from proceedings, from the courts, etc., from people who are aggrieved and could otherwise have exercised the right to seek redress in courts of law. Even judges have that immunity. The executive arm of government also has some level of immunity. So the issue of immunity is a creature of the Constitution itself. So I am not too sure that the High Court has the power to, as it were, if you like, topple the immunity that the Constitution has expressly granted to members of Parliament. And so these are matters that we would want to test further at the court, which has the exclusive province of interpretation.
Do I hear you saying that you would take this matter up at the Supreme Court?
Absolutely. These are matters that need to be tested so that we put matters to rest once and for all. Because we are strongly of the view that the issue of parliamentary immunity is guaranteed by the Constitution. And so no amount of application of the law can topple that. So we think that it's an area that would want to test further and to vindicate the framers of the Constitution on the issue of parliamentary immunity. And let's not make a mistake. Nobody has said parliamentarians should
above the law
from the jurisdiction of our courts. Nobody has made that point. All we are saying is that the Constitution clearly requires that whilst members of Parliament are attending Parliament or are on their way to Parliament or are returning from Parliament, they are immune from court processes.
And any other time, I guess the Speaker had made a point, you can indeed do the service. I'm grateful that you joined us with that thought. And so on two legs, the lawyers for Ayariga have just told us that one, they're going to appeal against the ruling on the matter, and secondly, they are going to go to the Supreme Court on the subject of his immunity. I want to bring in the leadership of Parliament. Let's speak to the majority leader, who is also the Minister for Parliamentary Affairs, Mr. Chairman Sabonsu, who himself is seized with this matter, and Parliament is discussing how to resolve this matter amicably. Mr. Sabonsu, thank you for your time here on Top Story.
Thank you for having me on your program.
And today, a lot of verdict was delivered, and there's a part of that verdict I just want to read. It's just a one-liner that I guess captures the essence of what the court believes. And the court was responding to the second letter that the Speaker had written to the Registrar of the High Court on the subject of parliamentary privilege and immunity of Honorable Mahama Ayariga. This is exactly what the judge said today in her ruling.
That portion reads, there will be no situation, to borrow the words of Justice Adenyira in the ex parte case of Francis, conducting the business of the court as though it is secondary to that of counsel or anyone else for that matter within the confines of the proper exercise of judicial discretion. The court will be sure to deliver on its mandate to preside over this trial like all others before it in a fashion that will terminate it timeously. It ends by saying that the presiding judge has to have control over his court.
Okay, so Mr. Moses, so that's where the High Court stands on this matter, and it's a direct verdict on the Speaker's latest letter to it. What's your reaction to this?
Thank you once again. The issue of immunity of parliamentarians and indeed some other senior staff of Parliament is a matter that must be handled carefully with a lot of circumspection. The Article 117 of the Constitution is clear that civil or criminal processes coming from any court or place out of Parliament shall not be served on or executed in relation to the Speaker or a member of or the clerk to Parliament while he is on his way to attending at or returning from any proceedings of Parliament. That is Article 117. Then 122 provides an act or omission which obstructs or impedes Parliament in the performance of its functions or which obstructs or impedes a member of or an officer of parliament in the discharge of his duties, or affronts the dignity of parliament, or which tends either directly or indirectly to produce that result, is contempt of parliament. Now, so on the face of this, a member of parliament enjoys tremendous immunity. Article 17(1) of the Constitution also provides that all persons shall be equal before the law. So it is the reason why I'm saying that we should be circumspect in, putting the 2 or 3 provisions together and carefully analyzing them. The provision in the Constitution which grants immunity to Parliament really is to ring-fence members of Parliament, some senior staff of Parliament, from the capricious or arbitrary exercise of authority or power from the executive or whoever. And of course, we know the history that produced this provision in the constitutions of all Commonwealth countries in the world. Now, is it the case, stretching it, that a member of parliament can, and I'm not citing the case of Ayariga, is it the case that a member of parliament could, for instance, on his way to parliament, knock down a pedestrian and decide not to stop or report the matter to the police and take refuge in parliament? That, well, I was on my way to parliament, and so I'm above the law, or I cannot be accosted by the law. Is that the case? Should it be that maybe I fall foul of the law, and from parliament I'm saying to everybody that, okay, I'm going to Kumasi. I'm not going to my house in Accra, I'm going to Kumasi. I'm on my way from parliament to my house, but my house is in Kumasi. I'm driving there. I get there the following day, I'm driving back to Accra to parliament. So I cannot be accosted. It is the reason why I think that we should be very careful. In the case of Ayariga, the difficulty is, and I am in favor of really protecting parliament and parliamentarians from, arbitrariness on the part of the executive. I'm not saying that this executive is arbitrary. I'm just saying that I'm a believer in that concept.
What about if that arbitrariness is coming from the legislature, the judiciary?
Well, I'm saying that I believe in that concept. In this case, the Ayariga case, that's why I'm saying that we should be very circumspect. In the Ayariga case, he's joined in a suit by another civilian. Now, should it happen that the civilian should be tried expeditiously, maybe in a week's time, and Ayariga is left because he's a member of parliament, what would be the sense of the equality before the law in this particular matter? I think that members of parliament should enjoy immunity and privileges, but then we should weigh it against the greater good of society. I don't want to pronounce on the ruling from the tragedy.
The High Court, yeah.
Yes, but I want us together as a house, and that is the issue that I raised the previous time in Parliament, that we should come together and be informed by best practice. Ghana is not an island in this world. I will know of similar incidents in some of the Commonwealth countries. In the case of Ayariga, for instance, apart from the fact that he's a member of Parliament, and on almost daily basis, he's coming to Parliament, he's leaving Parliament, he's attending to the business of Parliament, he's also in ECOWAS Parliament on behalf of Ghana's Parliament. And as I speak now, there is a meeting going on elsewhere, outside Abuja. It's what they call a delocalized meeting of one of the committees. He must be attending that meeting. So apart from what work he does for Ghana's Parliament, he also does some work for the ECOWAS Parliament. How then, if he has fallen foul of the law, how then can we, institute proceedings against him? I mean, the country, the state, do that. Or is it the case then that we should wait until 4 years, after 4 years, practically, because on daily basis he's on the move. So I think that as a parliament, we should sit down. And unfortunately, the courts have not been also very consistent in this. You remember the case of our senior colleague, Dana Bodapi. He raised the matter in the court. His lawyers raised the matter, and the matter of immunity was upheld by the court. And it was decided that his case would be heard only on Mondays or on days when Parliament was not sitting, or especially when we went on recess. But Adamu Sakande's case took another turn, where his plea was not upheld by the courts. There's another person, Samuel Nimakan, who was also with the NDC, and his own case was another matter relating to elections, and he was alleged to have engaged in some fraudulent misrepresentation. Again, his own case was not upheld, and he raised it, it was upheld, and then it was taken upstairs, and then it was withdrawn, and he faced the courts, and then had to leave the system. So the courts have not been very consistent in this matter, and that is why I'm saying that we should be very circumspect. And as a house, we should come together and be informed by best practices elsewhere.
Is there a point? Is there a point, because this is the second time the court has ruled, and there seem to be these two, arms of government seem to be at opposite ends of this. Is there a point where the two of you sit down at some point to try and deal with this conclusively? We've heard already from Ayagas that they're going to the Supreme Court. Is this something that you submit to and you back, or there's a way that you can discuss this at an administrative level between the two arms?
Well, if a person gives an indication that he wants to go to Supreme Court, what can be done to stop the person? And let's not forget, there are, as we understand, there are some others whose cases are being processed. So if the matter should be taken to the Supreme Court and the Supreme Court will resolve it once and for all for us, taking both the letter and the spirit of the Constitution and give it a very purposeful interpretation, a very purposive interpretation, I should say, I guess the nation would emerge the stronger.
How many more MPs, you say, are there cases still in the pipeline to be possibly prosecuted by the SP? 8?
Well, I'm not in the position to tell you how many.
Okay.
Those of them that have come before us, the initial one, the first one involved Yana Boyaraga, and then the second list that came, and I think about 5 or so other members, about 5 or 6 other members. All requests
from the SP.
Yes. So we are dealing with those ones, and so. But I think the cases have not gone to court yet, but he has made a request to the Speaker in respect of those 5 or 6 others. So,
and what is he asking for when he says request? Is he asking for you to grant a certificate for them to release, or just simply bringing it to attention?
No, he's requesting the Speaker because the Speaker certificate would be evidence that the person is attending to the business of Parliament, or maybe the person has signaled that he's on his way to Parliament or leaving Parliament. And so he was requesting the Speaker to grant permission so that they could go on with the trial of these named persons. As I'm saying, we've had some initial engagement with the special prosecutor, but I believe we can still put our heads together on that. We, on our part, we said we're going to put together a small committee to be informed by best practices and advise Parliament. We haven't gotten around that business yet, and then this case has shot up. So I think we can work together and see the best way of expanding, as I said, the frontiers of democratic governance.
I'm grateful that you joined us. That is the Majority Leader and Minister for Parliamentary Affairs there, speaking to us on this unfolding drama between the legislature and judiciary. News Night starts right now.